Hello everyone, welcome to my channel Study with Neha Mava. Today I'm back with the another video in which I am going to teach you about BNSS. What is BNSS? What are the various amendment that has been done in the BNSS? So without wasting time, let's get started. So today I am going to teach you the Bhartiya Nagrik Suraksha Sanhita 2023. We know BNSS is a new act that is earlier was the CRPC, but now it has been changed and by the name is Bhartiya Nagrik Suraksha Sanhita 2023. Now firstly what we have to start with, we know earlier it was CRPC, that is Criminal Procedure Code. Now it has been changed to BNSS part. Now, Bhartiya Nagrik Suraksha Sanhita, as we all know, is a procedural law. It tells about the procedure, how to arrest a person, how to make the person punished of any offense that the person has done. So, BNSS is a very interesting subject. So, without wasting time, let's get started. First of all, we are going to start with chapter number 1, that is the preliminary part. Firstly, it says that we have two things here. First is the enactment part, other is the commencement part. Firstly, BNSS was enacted on 25th December 2023 and came into force on 1st July 2024. So firstly it says this act may be called the Bhartiya Nagrik Suraksha Sanhita, that is 2023. The provision of this Sanhita, other than those relating to chapter 9, 11 and 12, does not apply to state of Nagaland and tribal areas of Assam. Generally, we all know BNSS is applicable to all over India, including your J&K. But there are some areas where BNSS is not applicable, and what are those? First is the state of Nagaland and tribal areas of Assam where BNSS is not applicable. But some chapters of the BNSS is applicable to the state of Nagaland and tribal areas of Assam, that is chapter number 9, 11 and 12. These three chapters, they are applicable to state of Nagaland and tribal areas. But the concerned state government may by notification apply such provision or any other them to whole or part of the state of Nagaland. Now it's fully dependent upon the state government whether they want to apply the whole part of it or the portion of it. It depends upon totally on the state government. Then we have explanation part here. In this explanation part, tribal areas means the territories which immediately before the 21st day of January 1972 were included in the tribal areas of Assam as referred to in paragraph 20 of 6th schedule of constitution. Now you have to be very much keep in your mind about the date, that is 21st day of January 1972. It shall came into force as central government may by notification in the official gazette appoint, that we all know, 1st July 2024. Now in this Sanhita, unless the context otherwise require, now we have all the main and important definition that we have to go through. So we have the definitions part here. We are going to study the definitions one by one. First is the audio video electronic. Now, audio video electronic means shall include use of any communication device for purpose of video conferencing, recording of procession of identification, search and seizure or evidence, transmission of electronic communication and all. Now, audio video electronic means where earlier only the written thing was considered as the evidence in the court of law, but now BNSS has recognized audio video electronic form to be a part of the evidence, to be a part of the BNSS. It says that it means the communication that we do. Like we all know, after Corona, the online platform took a very sharp rise. Okay, so communication device, that is like if you're doing video conferencing, you are chatting on WhatsApp chat, and the recording, the video, everything will be considered as the evidence, and nobody can deny its admissibility. Then we have the bailable offense. We have two offenses there, bailable and non-bailable. But first we have to start with the bailable offense. Bailable offense means the offense that is bailable, that is not that serious, where bail cannot be granted. In bailable offense, bail is a matter of right, where it is your right to get the bail if you have done the act that is not that serious. But it also tells about the bailable offense is the offense which is shown as bailable in the first schedule. Okay, and same is the non-bailable that we will study later on. Then we have the charge. Now whenever we are studying or reading the charge means the head of the charge, or it may be more than one head of charge. For example, a person, he may be charged with the robbery, he may be charged with the culpable homicide, he may be charged with the theft. So there could be a one charge, there could be the more than one charge. Then we have the cognizable offense. Cognizable offenses are those offense, those who are very, which are very of serious nature. They says that cognizable offense means where a police officer has the power to arrest a person without warrant. Here the police officer may arrest the person without warrant because that offense is very serious, very heinous, that there is a requirement to arrest that person as soon as possible. Then we have the complaint part here. Complaint means any allegation that is made orally or in writing to magistrate. Keep in your mind, complaint is always given to the magistrate, not the police officers. If the complaint is given to the magistrate, it is admissible, but if the complaint is given to the police officers, it is not admissible. Complaint given to the police officer is not admissible at all. Then we have, now the complaint which you give to the magistrate may be in oral, may be in writing. If it is oral, you have to be, reduce it to writing, and then you have to present a report made by police officer in a case which discloses after investigation the commission of non-cognizable offence shall be deemed to be a complaint. Then we have the electronic communication. It is very, very, very important, and nowadays most of the transactions are being done electronically. Electronic communication means when you are communicating with the other person via electronic means. It could be pictorial information, it could be through video content transmission, it could be a telephonic, it could be a mobile, or anything that is the wireless communication. So electronic communication means when you are not in physical presence with the other person, when you are communicating through electronic means. It could be email, it could be WhatsApp, it could be Facebook, Instagram, but you are not physically present there and interacting with the person. We know what high court means. High court means in relation to a state, every state has their own high court. In relation of a UT, okay. Then in relation to a UT, the highest court of criminal appeal for the territory other than Supreme Court of India. India means territory to which Sanhita extend. We know what is India. Now, inquiry means inquiry other than trial. We know investigation, inquiry, and trial. Inquiry is where you are starting your proceedings, right? Then investigation means collection of evidences, where evidences are being collected. Then we have judicial proceedings here. Judicial proceeding means any proceeding that is going on, okay, and in the course of evidence, mean legally taken on oath. It says that judicial proceeding means proceeding is going on after taking the oath. Local jurisdiction means the local jurisdictions of the court within which they have to exercise their powers. Local jurisdiction in relation to a court or magistrate means local area within which the magistrate or the court can exercise their powers. Out of that, they cannot. Non-cognizable offences means those offences where the police officers cannot arrest a person without warrant. Here, the warrant is very much required to arrest a person. Then we have the notification part. Notification means the notification that is published in the official gazette. Offense means any act or omission made punishable by any law for time being in force. Offense, we know, offense means something which is very bad or which is strictly prohibited by law, and still you are doing, that is punishable by law, and still you are doing, it's the offense. Then we have the officers in charge of a police station. In every station house, in every police station, there are officers appointed where they have the responsibility given to perform their duties. Now, officer in charge of a police station, they have to lodge the FIR, they have to file the, various information that they, uh, you know, get. So then we have the place is the house, building, tent, vehicle, and vessel. Pleader. Pleader means advocate or a person authorized by the law to present their case in front of the magistrate, in front of the court, and to start the proceedings. Police report, we all know. Police report generally is forwarded by the police officer to magistrate. We have the police station, we all know, that is established in the state or local areas. Then we have the public prosecutor. Public prosecutor means a person appointed under section 18 and includes any person acting under the direction of public prosecutor. We have the public prosecutor, we have the special public prosecutor, assistant public prosecutor, and additional public prosecutor. Then we have subdivision here, means a subdivision of a district. We have two, summon case and warrant case. Summon case is a case not being a warrant case, where a person has to, when a person is called in the court to appear, when a person is requested to appear in the court, generally we, issue summon. But when the person is avoiding the summons, when the person has done a serious crime and the person is not appearing in the court, then generally we issue the warrant. So it says that warrant means a case relating to the offense punishable with death, imprisonment for life, or imprisonment exceeding the 2 years. And the last, we have the victim part here. Victim means a person who has suffered any loss, injury caused by reason of act or omission for which the accused person has been charged. Victim is generally the suffering, the person who has been suffered against any act or omission that is, of course, strictly prohibited by law. Then we have the words and expression used herein are not defined but defined in BNS, IT Act, they all included in this. Then we have the construction of references here. Now, construction of references says unless the context otherwise require, any reference in any existing law to a magistrate, that is a magistrate of first class or a second class in relation to area, be constituted as JMFC or SC. We know there are session judges, there are judicial magistrate also. Now, judicial magistrates are those magistrates, who works judicially. They are categorized into two, that is JMFC and JMSC. Judicial magistrate of first class and judicial magistrate of second class. Now, they have to work within the prescribed area, within the powers which they have. Then we have where under any law other than Sanhita, the function exercisable by a magistrate relates to matter which involve the appreciation or shifting of evidence or formulation of any decision which exposes any person to any punishment or penalty, detention of custody, pending investigation, inquiry, or trial would have the effect of sending him to the trial. Now, JMFC and JMSC, they both have the powers, but their powers differ. So, they have to work according, they have to work according to their given powers, according to given jurisdiction. Last but not the least, we have trial of offence under BNSS and other laws. All offences under BNS 2023 shall be investigated, inquired, tried, otherwise dealt with according to provision herein contained. All offence under any law shall be investigated, inquired into, tried, and otherwise dealt with according. So generally it says that every offences will be dealt with according to the BNSS part. Okay, okay, so we know that if there is some special law or local law towards a particular act or the offense, then that special or local law will be applicable. Otherwise, BNSS will be applicable over there. We know the special or the local laws, that the POXO Act or the Juvenile Justice Act, these are the special laws, right? That we have to deal with according to that law only. But where these laws are not applicable or these laws are not present, then we can apply the BNSS, that is Bhartiya Nagrik Suraksha Sanhita. So this was the chapter number 1 of the BNSS. I hope you understood. Now, today I am just winding it off for the chapter number 1. If you like my video, please do subscribe to my channel, like my video, and I will be coming up next with the chapter number 2, that is Constitution of the Criminal Court and Offices. Till then, have a good day, have a nice day. Thank you.